which I'll answer questions and respond to comments you've made in your blogs as the summer class speeds toward its end. First one, the video of actually the GIF, or GIF. The person who created the GIF says it's pronounced GIF, but of course, in the state of the internet, there's a controversy, and people say that the creator of the GIF is wrong. It should be pronounced GIF. Anyway, the question was about the video, and it was, would the tweet or the GIF be libelous? Or, as you can see on the PowerPoint slide, is it okay because it's meant to be satirical? Well, the answer is it's not really going to be a libel suit. We do have the first two fingers of libel, the publication and identification, but as the student points out, it's meant to be humorous or rhetorical hyperbole. It isn't believable. Even if it was believable, what is harmful to the reputation of CNN? We're well aware that President Trump has criticized CNN on a regular basis, calling it fake news, but it's not defamatory. The GIF was traced to a private citizen who created and posted it. And of course, President Trump didn't create it or have it made, but he did tweet it out and gave it a lot of publicity. Next question about books that have come out that have been, well, critical of the Clinton family, and there are books critical of Donald Trump. And in a family conversation, a dad said, well, most of the books are libelous. Are these books considered libel? Well, let's start off with the five fingers, or actually the middle finger, defamation. And the threshold question when you look at defamation finger in libel is it false and wrong? Is it believable and also harmful to reputation? Do the books harm reputation? Well, they probably do. So you may ask yourself, why aren't the Clintons or President Trump suing for defamation? And the answer is, if anybody sues for defamation, they have to submit to discovery. And remember from the videos preliminary to the class, in discovery you have to answer questions in writing and also through live testimony, which means that the defendant publisher could ask all sorts of questions related to the Clintons or President Trump. President Trump would have to give up his tax returns. He would have to disclose his business dealings. Hillary Clinton would have to testify about her husband's affairs and how much money she makes giving speeches to wealthy business persons. It is for this reason that a lot of people don't sue when defamation occurs. There was a publication called the National Enquirer. You might ask your grandparents about that. And it was filled with salacious stories about Hollywood stars and celebrities. Very few people sued. And the reason they didn't sue is because they would have to submit to discovery. And doubtless the answers they gave in discovery would wind up somewhere being published, probably in the pages of the National Enquirer. So you can have defamation out there, but it's not worth the time and trouble and the disclosures that a plaintiff would have to make. Here we're talking about the Summit Hotel case and the WBOX case out of Bogalusa, Louisiana. And it's true. You need to be sure that before you put somebody on the air live, that you know what they're going to say, or at the very least, be confident that they're not going to say something libelous. And the question is, how can you effectively screen somebody to be sure that that person won't say something libelous on the air? The answer is that as you get more experience as a reporter or a PR professional in dealing with people, you'll start to develop instincts that are going to help you decide when people are not reliable, when people are erratic, more likely to say something inappropriate or even libelous. In fact, you already have this ability, which is why some of the people you hang out with in college are not people you would want to introduce your family to when they come up for a visit, because you know this gonzo person who you hang out with is likely to say something inappropriate about you or what you do at college or just things in general. So it's a matter of developing your ability to read people. Um, the safest thing is never to put somebody on the air if you have a doubt. So the person's wearing a really weird outfit or has a shirt that says Hillary runs a child sex ring. Remember, of course, that was something that became prominent in the 2016 presidential campaign, or they're wearing a shirt saying Donald Trump grabs women by their lady parts. You would not want to go live with that person, because if they're willing to wear an article of clothing that has an outrageous statement, it's possible, maybe even likely, that they're willing to say out loud some outrageous and potentially libelous statement. So, also related to going live, who has the liability? Who's at risk? Well, the publisher is liable, the publisher at risk. And usually that means the station or the website, because the station or the website has money. You as the reporter don't have a whole lot of money. That's one of the things about journalism that makes it like joining the priesthood. You don't take a vow of chastity, but pretty much you are taking a vow of poverty. That's a journalism joke. So in most cases, in all cases, we sue the publisher, the station, the website, the owner of the company, and the company itself. Occasionally, the reporter or interviewer gets sued as well, because the plaintiff is really ticked off by what the reporter or interviewer has done. In the MMAR versus Dow Jones libel case, the reporter was a named defendant, and at the end of the case had a $70,000 personal judgment hanging over her head until the judgment was vacated because of improper behavior by the plaintiff. So keep that in mind. In any event, if you are the person who puts somebody live on the air who says something libelous, your prospects of working at that one place until you retire and get the gold watch is not going to be particularly good. Now, I will tell you that if you get your employer embroiled in a libel suit, they are going to, in most cases, treat you very nicely. They're going to treat you with tenderness. They're going to talk about how, well, the plaintiff is a terrible person. You did what you could. You may have made a mistake. And the reason they're going to do that is they want you to be sympathetic to your employer, because your employer is the one who has a lot of money at risk in a libel judgment. In libel cases that I've worked, in cases that I've read about, the reporter or PR person keeps the job until the case is over. And once the case is over, that person gets fired. The reason nothing bad happens until the case is over is because your boss does not want you to leave employment angry, because you still have to go through discovery. You still may have to go through testimony in court. And if your boss fires you when you testify in discovery or in trial, you are likely not to say things helpful to the defense. In fact, you may even put a little spin or shade on things to make your company look worse. When you are the person who apparently screwed up, you're fine until the case is over. Here we have a question about the status of a plaintiff. Remember the story from United Airlines, one of many, which have come up in the past couple of months. David Dow was the fellow who was dragged off the plane bleeding. Some news organizations reported in the follow-up to the story that he had committed felonies and had his medical license suspended. So the question is, if those stories had been false, of course they're damaging to reputation, and Dr. Dow sued for libel, would he be considered an involuntary public figure because of the airline incident? Well, yes, he would be considered an involuntary public figure because he didn't necessarily want that publicity or being thrust into the international spotlight. Uh, but just consider him to be a public figure who has to prove actual malice. All right, here's a comment from one of the blogs. So, in response to that question, there are some things I don't want you to look at in the libel section. I don't want you to pay attention to the Rosenblum case or the Bandidos case, because those cases in the rule that govern their outcomes are not universally accepted. It's kind of like in the first part of the class where I told you not to read the cases that come before Stanley, Ginsburg, and Miller. I didn't want you to read the Roth case. I didn't want you to read the case about John Cleland's Memoirs of a Woman of Pleasure, because although those cases were correct for their time, they do not reflect contemporary law. So Rosenblum, Bandidos do not reflect majoritarian views, the majority of jurisdictions in contemporary libel law. Similarly, I don't want you to look at the neutral reportage cases, because neutral reportage is not widely accepted in the courts. In fact, California has rejected, or actually passed on the notion of applying neutral reportage. So if you read the neutral reportage, and if you read the Rosenblum and Bandidos cases, you are likely to use them in an answer on a test question, and it will be wrong. So for our purposes, for the purposes of test 2, which is coming up this Thursday, actual malice is, as it says in the book, knowledge of falsity or reckless disregard of the probable falsity of the published statement. Knowledge of falsity means you published it even though you know it's false. Now, knowledge of falsity also can apply to the alteration of quotes, where the alteration of the quotes creates a new defamatory meaning. And even though I don't put it in the section of the book about knowledge of falsity, it comes after the section about reckless disregard. In a libel case, if you have a quotation that you were given by the plaintiff, let's say that you have a recording of it, or the plaintiff recorded the interview, when you change that quote and it creates a different meaning, well, obviously you knew what the original quote was and you changed it. So it's easy to argue in court that that is a situation in which there is knowledge of falsity. Reckless disregard. We have 4 ways that the courts have found that establish that the defendant publisher published with reckless disregard. The first, of course, is reliance on an obviously biased source. Now, the Stevens case is about a reporter who pretty much has a one-source story, and the source is the ex-sister-in-law of the state senator who's suing for libel. This doesn't mean that if you're doing a story that you can't talk to somebody who doesn't like the plaintiff. If you were doing a story about Donald Trump, you of course would include interviews with people who disagree with his policies and his positions. That's not a case of relying on an obviously biased source. It is a case of having balance to your reporting. It is when you rely overwhelmingly on the obviously biased source. And the story, of course, has to be false, wrong, and damaging to reputation. That's when that reckless disregard is found. The publishing an inherently improbable story, Well, I've got a question a little later on in the video about the Hunt versus Liberty lobby. If the story doesn't make sense, you shouldn't be publishing it. If the story is that Donald Trump is an illegal alien, he's an illegal alien from the planet Mars, well, that's highly improbable. And so if you publish it, then you probably deserve to be sued for libel. Of course, then again, is such an improbable story something that's believable? That's something we might take up in a later video. Number 3, failure to contact a necessary and obvious source. Now, as I said in the video and from the early videos where we went through Iraq and the case involving the state judge, John Jameson, failure to contact a necessary and obvious source doesn't mean that you have to hold a story until you talk to every single person who could be talked to. Making a good faith effort to get in touch with someone is enough. The failure to contact a necessary and obvious source, as I said in the lecture and in the book, is something that's kind of like willful blindness. In other words, where you deliberately close your eyes so you can't see the truth. And in the Connaughton case, the reporter had an audio recording of the conversation that was at the heart of the story and the libel suit, and he never listened to it. So that's what I mean by failure to contact a necessary and obvious source. In the example with Judge Jameson, the fact the reporter couldn't get in touch with Judge Jameson did not prove failure to contact a necessary and obvious source, because you saw in the fact pattern that there were multiple emails and phone calls, and because the judge was out of the state, it wasn't possible to talk to him before the story was published. And you have to remember that there are deadline pressures, and having worked as both a reporter and editor, I will tell you that sometimes sources will avoid reporters in the hope that they will delay the publication of a damaging story. Or sometimes they will duck a reporter in order to be able to go to a different news organization to preempt the reporter's scoop or to put a spin on the facts. So we won't hold a story just because somebody is not available to us or won't talk to us. Because if we've made a good faith effort and we can document that, then it is not a failure to contact a necessary and obvious source. For publishing a story despite having doubts about the truthfulness of the story, of course, that's the Aiken versus Altus newspapers. If you're in the newsroom and you say, well, I don't think the story is true, but let's go ahead and publish it. Well, definitely that's reckless disregard. In the Aiken's case, I think that the questions that were asked, have you checked this out, didn't really show doubts about the truthfulness of the story, but rather were simply questions that an editor would ask of any reporter or of any editor with a story as significant as that one was. There, I think the Oklahoma courts kind of overreached themselves, but it's still good law. So if you have evidence that in the newsroom or in the PR firm they said, no, we don't think it's true, we have doubts about the truth, but let's go ahead and run it, well, that's proof of reckless disregard. Here's one about something in the news now, a lawsuit against John Oliver from last week tonight. Mr. Oliver talked about the efforts to bring back coal. He talked about Murray Energy. He referred to Mr. Murray as a geriatric Dr. Evil, and talked about safety violations at Murray Mines. You see here there's a URL to the video and also a story about that. And the question from the student is, how likely is it that Mr. Murray's going to win? Well, yes, John Oliver and Last Week Tonight were sued. It's not likely that Mr. Murray will win for a number of reasons. Number one, the plaintiff has to prove that the public statements were false. And if you watch the segment of Last Week Tonight, and you also watch the news story that followed the filing of the lawsuit, It doesn't appear that the statements were false. The segment about the claim that an earthquake caused the deadly mining accident looks to be true based upon the report on the cause. Murray Energy quoted from the report where they said it was a slip, which they said was an earthquake, but in the section preceding that quote, it was made clear that it was the activity at the mine that caused the slip. It was not a natural earthquake. The claim about the mistreatment of the employees and their families is clear from the video of family members who criticized Murray Energy for their response to the mining accident in Utah, and reports about Murray Energy and how it downplayed the need for protection against coal dust and black lung disease. And as you saw, there was a segment about a squirrel. And in this segment, of course, John Oliver says there's an apocryphal story. Well, apocryphal means a story that really is doubtful as far as its authenticity, but it's circulated as being true. And the story was that Mr. Murray, is that Mr. Murray tells a story that he was sitting on his porch one day and a squirrel came up, sat in front of him, and said, "You should own your own mines." And of course, on Last Week Tonight, they had a guy in a squirrel suit running around talking to people. The reference to the squirrel is satire. It's humor, and humor is not believable. That's why we only have a couple of libel suits in the textbook over jokes, because people don't sue successfully over jokes. The fact that John Oliver had a guy running around in a squirrel costume only adds to the point that it's humor and therefore not believable. So, you can watch the case, but I'm fairly confident that the case will be dismissed, or even if it doesn't, that Mr. Murray will lose at trial. Question about republication, and the doctrine of republication is that if you repeat somebody else's defamatory statement, you adopt it as your own. And it's true that when I talk to broadcasters, the news directors, they say, "Oh, wait a minute, how can this be so? We didn't say the bad thing, we just ran the tape of the person saying it." Well, that's still republishing, because the station has chosen to put that statement out over the air. And the question is, what if you're just sharing the story as a journalist? If the statement is already out and you're just sharing it with somebody else, is that spreading the news further? And it's confusing. Well, sharing a story, spreading a story, is republication. The words are coming from you, and the words are the story that's damaging. So when you republish a story, you're the person who is choosing to put it out there before the public. Therefore, you have liability, and the person who is the subject of the defamatory story can choose to sue you. Now, there are certain circumstances in which we have protections, and remember qualified privilege. If there is a privileged proceeding, such as a legislative hearing or a court proceeding, then we have qualified privilege to publish those statements as long as they are fair and accurate. If the police make a statement, or if there's a police report, we have a qualified privilege in most states to republish those police reports or police statements. So that's an instance in which we can republish something and we are free of libel liability. A question about group defamation, and it's a reference to the Neiman Marcus case. Remember, we had 9 high fashion models, I think about 25 salesmen, and then a couple of hundred saleswomen. The book USA Confidential libeled all 3 groups, saying that they were either prostitutes or, and you have to understand the time, that they were gay. And being called gay at the time of this publication was, in fact, defamatory. And so the 9 high fashion models could sue, the dozen or so salesmen could sue, but none of the 300 saleswomen could sue. That's because the courts have decided that when a group is large and the group itself is libeled, then no one individual member of the group has been libeled with the particularity needed to bring a libel suit. So the 9 high fashion models were in a small enough group, the salesmen were in a small enough group, the hundreds of salesmen were in too large a group. Remember, libel is a personal tort. Only you, the person libeled, can sue. Your parents can't sue, your children can't sue, your spouse can't sue, only you. Because it is a personal tort, it belongs to the person whose reputation was damaged. It belongs to the person who was personally identified. So, if you're a member of a large group, and the large group is libeled, let's say you're a student at Cal Poly, and somebody publishes a story that says, all the students at Cal Poly have a loathsome disease. Well, you personally have not been identified. So no identification takes place. If you're a member of a small group, let's say students in the summer 302 class have a loathsome disease. The group is small enough so that the courts say you all have been personally identified. Now, there is a wrinkle to this. If you say 2 things, number one, all students at Cal Poly have a loathsome disease, and then we say you're a student at Cal Poly, those 2 statements together create identification and defamation. If the statements are widely separated, in other words, on Monday the person says you're a student at Cal Poly, on Friday the person says all students at Cal Poly have a loathsome disease, then they're not connected up to give you, the student, identification for a libel suit. But if they're said in the same sentence or the same paragraph, then we would have identification. But merely saying that all students at Cal Poly have a loathsome disease, and it's not true, doesn't provide personal identification of you as a student. Another question about identification, somebody named Emma who works for Mind Body. In fact, I hope that there is no Emma who works for Mind Body. But anyway, so a journalist writes something about Emma who works at Mind Body. There's another Emma who works at Mind Body, and people thought you were talking about the second Emma, and it was a defamatory statement. Would that be considered identification for a libel suit? Do we need proof that people are thinking I'm referring to her? Well, identification is based on what the audience thinks. If the audience thinks it is the second Emma, then she has been identified. And by the way, with respect to the question, is she just trying to make money? We've studied libel suits and we've studied libel plaintiffs, and we find that the reason most libel plaintiffs file suit is to get vindication, not money. It's to be able to say, oh, that guy was wrong, and it's not true what the person published about me. Another identification question based upon Washington Post versus Kennedy. In that case, the court found that most people who saw the article thought it was about Harry Kennedy from D.C., and therefore Harry Kennedy from D.C. was identified and the libel suit went forward. Is there a general rule of thumb for the number that allows the case to be considered, well, for identification to be established? What if it's just 3 people or 1 person? Well, the answer is there are no court cases on the minimum number of people who identify the plaintiff as the person identified in the suit. Now, having said that, if 1 person comes up and says, oh, this story is about Bob, well, 1 person is not going to be enough. 3 people not going to be enough. Let's make a comparison to the Peck case. Remember, Peck was about whether something was defamatory or not. And before the Peck case came along, it was, what would right-thinking people think about this? Is it defamatory in the eyes of right-thinking people? Well, in the Peck case, you'll remember, on appeal, the appellate court said it's not a matter of a majority, but rather if a respectable and significant minority of the people think it's defamatory, then it's defamatory. So, for identification, If it's a significant and respectable minority of the public that thinks the person was identified, that should be enough. Now, let's say it's, um, let's see, McDonald's. Uh, as you know, McDonald's has large crews, maybe 20, 30 people at the McDonald's. If somebody publishes something defamatory about an employee at McDonald's, and the employee's name is Bob, and some of the people at McDonald's in this crew of 30 or 40 think it was about the second Bob. Well, if you look at the absolute number, maybe it could be 3 out of 30. That might be a significant enough minority to establish identification. So, that's possible. Remember, of course, though, we are not likely to have a case in which only 1 or 3 people think the person has been identified. Remember that libel is about reputation, how people see you. And so, for a libel plaintiff, you're going to want to bring up a lot of people who know you to show that your reputation was damaged. The dog in the background is our terrier Zuma, who apparently has heard somebody drive past. Identification, of course, it must be of and concerning the plaintiff by name or image or video or special attribute. The question is, how would they base who is the audience, and how do they measure what the audience thought fairly? Again, how do we know who was identified? Well, of course, it's one of the 5 fingers of libel that must be proven by the plaintiff, which means the plaintiff has to present credible evidence that people believe the published statement was about the plaintiff. That means testimony about who people thought the publication was about. So the plaintiff is going to have to bring people in to say, oh, I saw this and it's about the plaintiff. The defense may bring people in to say, well, no, I read this and it was not about the plaintiff. That's not going to carry a lot of weight. It is how many people thought it was about the plaintiff that's most important. It's not a balancing. It's just if the plaintiff can bring witnesses forward to say that they believe the publication was about the plaintiff and it damaged the plaintiff's reputation, that's enough. So, let's say the plaintiff brings in 100 people who say the story was about the plaintiff. The defense might want to bring in 500 people who say it wasn't about the plaintiff. Those 500 people are not relevant. It is the 100 people who are relevant. And so the matter for the court is to determine that those 100 people in fact thought the publication was about the plaintiff. Question about the Communications Decency Act. Recall, of course, that ISPs are protected from content they carry, but not content they produce. And so the question is, and this is actually a good question, what if the owner is putting content onto the site under a different name or anonymously? And we have had that happen a number of times, where a publisher of a website or an ISP will anonymously slip something in order to be able to attack somebody or to generate buzz about the website. So we're going back to discovery, and in discovery we get to find out who posted the content. When people go onto a website, they have a traceable Internet Protocol address, and we can look at the Internet Protocol address to see who the person was. Record companies, movie companies, looking for people who are illegally sharing content use IP addresses. And so here I might direct you to page 989 at footnote 216 to see how that works. That's a case from the copyright section in which a woman by the name of Jamie Thomas Rassett was sued by the Recording Industry Association of America for illegally downloading songs. Now, she claimed that she didn't illegally download, but 3 juries found that she did. And the evidence that she had downloaded was that the IP address and the username for the account used to download were uniquely tied to her. So um, it's just a matter of effective discovery. Now, I will tell you that a lot of internet service providers do not want to cooperate with discovery. They don't want to be involved in a libel suit, and occasionally they will fight to protect the identities of people who post. And it's kind of an uneven set of results. In some jurisdictions, the courts have said, no, you have to provide the information because it's not available anywhere else. In others, the courts have said, well, you can't force this non-party, this ISP, to provide this evidence. So it's kind of hit and miss. As the internet has become more ubiquitous, as social media has become all-consuming, I'm thinking that we are likely to have more cases in which the courts say, yes, it's important to find out who the publisher is, and forcing the ISPs to give up that information. Jurisdiction. Of course, you know that the plaintiff can sue when the defendant has minimum contacts in the jurisdiction where the plaintiff wants to sue. And this is not really a minimum contacts, but the question is, what if you're in California, your broadcaster, your signal goes to Nevada, you're doing business in Nevada and can bring suit in Nevada. What if state laws are different and something that was found in California but not in Nevada was broadcast? How would that play out? Okay, let's start off by saying it's probably going to be more a case involving something legal in Nevada that is not legal in California. You may or may not be aware of this, but in some counties in Nevada, prostitution is legal. A publisher, and it doesn't have to be a broadcaster, because it could be a website or a newspaper or magazine crossing state lines, publishes a story that says John Doe is a prostitute who works in one of these legal brothels in Nevada. Now, we're assuming that the statement is false. If it's true, then Doe has no case, because, of course, under the third finger, defamation, the threshold question is it false and wrong? Now, being falsely called a prostitute in California is damaging to reputation, because that is a claim that a crime has been committed. Prostitution is a criminal act. Now, also be aware that even though prostitution is legal in some counties in Nevada, under the Peck case, being called a prostitute could still be damaging to reputation and could be the subject of a successful libel suit. Identification more of and concerning. All right, let's move on here. Defamation per se and per quod. I briefly touch on this. I say it's law speak, and we shouldn't worry about this. So you also have the admonition not to use the terms on the final. And the question is, why are you putting this in here if we shouldn't know this for the exams? Well, they are elements of the defamation figure on its face or arising from the context. I don't want students to try and use those terms because, in my experience over the years of teaching this class in the libel section, that per se and per quod are frequently misapplied by students when they try to use those terms. They talk about you publish something per se or you publish something per quod, and that's not really what the terms mean. So rather than leave that landmine for a test answer out there, I just want you to avoid this. Now, per se and per quod are in the middle of the libel section. You're likely to read them, but I don't want you to use them. But they appear in the book because this book is used by some grad school classes and some law school classes, and those students need the more detailed information about libel. So those students also have more of a grounding in the law, and so it's not like an undergraduate class where you're being introduced for the first time to these unfamiliar concepts. So understand that they exist, just don't try to use them. You are likely to get yourself in trouble on a test answer. The question is, are the tests cumulative? Well, each test covers all the material in each part. The exception next Thursday is going to be that I'm going to include a makeup question from test 1. Now, because each test only covers the material in each part, the third exam is not a final, but rather is simply the third test in the class. It will only cover the materials in the last section. And a question about when the exam is going to be. The third exam is going to go out Thursday, July 27th, and be due on Friday, July 28th. That's the end of the 5th week of classes. Another question about libel. President Trump said he was going to open up libel laws, make it easier for him to sue. Well, is it possible for Supreme Court justices to overturn New York Times versus Sullivan? So, to begin with, libel laws can be changed. States have the ability to change some aspects of libel law in terms of liability and proof, but what can be changed is the First Amendment, barring a constitutional amendment. Now, it is true that the Supreme Court could get a libel case and reject or modify the ruling from New York Times versus Sullivan to make it easier to win a libel suit, but it's not likely to happen because New York Times versus Sullivan is settled law. It's been settled law for, 1964, so 36 plus. It's been settled law for more than 50 years. And we now have a majority of conservative justices on the Supreme Court. And if you look at the court cases, you'll find that conservative justices have been more friendly to the First Amendment than the so-called liberal justice. So, while we haven't had a whole lot of libel cases going up in front of the Supreme Court, I don't really see any majority of the court taking away the protections of Sullivan. And in lawsuits, is the New York Times and companies like it sued frequently, and is this a financial burden for companies? Well, to start off with, any libel suit is a financial burden. As you saw in the book, the most basic libel defense is going to cost you between $100,000 and $150,000. If you're talking about a company like the New York Times, you could be spending $250,000 or $500,000 just to defend your libel suit. In the Westmoreland versus CBS, it was estimated that each side spent about $4 million in the case that resulted in the court saying, well, CBS was wrong, but General Westmoreland hasn't proved actual malice, therefore he doesn't get a dime. So they're very expensive. Now, the New York Times does not get sued a lot, nor does the Washington Post, but that wasn't always the case. When the Sullivan case came around, the New York Times was going through difficult times financially. The owner of the New York Times had died. His heirs were paying an estate tax. The Times didn't have a whole lot of money. And at the time of the Sullivan case, the New York Times faced $3 million in libel damages in the state of Alabama. And to be sure, it was a real concern when the Times appealed to the Supreme Court because it was thought that $3 million could put the Times out of business. Of course, the Times is in better shape financially today. But defending libel suits, very costly, and they do pay a lot of attention to it. Smaller media outlets are at greater risk, and in the textbook you see the Alton Telegraph. A plaintiff won a $9 million judgment against the newspaper. It was later reduced to $1.4 million, but that $1.4 million was enough so that the family that owned the newspaper sold it and got out of the business. So, yes, libel suits are damaging, they're costly, they can put you out of business, which is why when you go into the business as an intern or as a new employee at a news organization or a PR firm, you have to be very careful about the language that you use and the quote facts that you discover, because your mistake on a press release or in a story can result in a libel suit that can put your company and your boss out of business. Here's a question about reckless disregard, inherent improbability. E. Howard Hunt. If he wasn't in Texas, did he sue someone for trying to frame him for this assassination? Or was the publication just reporting on the incident? Now remember, the Hunt case, Hunt versus Liberty Lobby, arose because of a false story in Liberty Lobby that the CIA was going to try to frame Hunt for Kennedy's assassination. There was no actual attempt to frame him, so there was nobody for Hunt to sue in terms of being framed. Hunt successfully sued Liberty Lobby for its false defamatory story about the fake story that they published. All right, so that ends your question. The test 2 goes out at noon Thursdays, due back at noon Friday. On Wednesday, I will post another video with answers to more of your questions about the material to be covered in test 2. So send them in so that you can have your questions or doubts or uncertainties resolved before you get the test at noon on Thursday. So talk to you soon. Goodbye.